Hello everyone and welcome to the webinar on subletting and unlawful profit orders and getting over the line from Cornerstone Barristers. Just a bit of housekeeping before we start. Can I please ask everybody to put themselves on mute? There'll also be some time for some questions also at the end in the function box, which you'll be able to use. So just to introduce myself, my name is Raj Vine. I'm the counter fraud specialist at Riverside Housing Association. And also we have Andy Lane, barrister from Cornerstone Barristers. So what are we going to be talking about today? We will be looking at the roadmap. So we'll be talking about subletting, unlawful profit orders, how to qualify and how to obtain and how to calculate, and getting the evidence and the importance of trial, gathering evidence. We won't be talking about total deceit today, compensation or confiscation orders or disgorgement of profits. And are Manchester United back? A big question mark there. So over to you, Andy.
Yeah, we're certainly not dealing with that last point. And I'm sorry, Daniel, I haven't managed to put the Eric Cantona shirt up behind me. Yes, what we are doing today really is off the back of a case that Raj and I were both involved in recently, which concerned subletting, and subletting with very, I was going to say limited evidence, but there was quite a lot of evidence, but not much direct evidence. And so we thought it'd be helpful to look at subletting and unlawful profit orders in the context of that particular situation. And indeed, some of your questions that you've already asked us in advance address that kind of question of the quality of evidence. And so what I'm going to be looking at is very much obviously the law, and Raj is going to be talking about her working actually creating the case and making sure the case is ready for trial. Because obviously, as you might imagine, all the hard work is done by Raj in this case. The first slide really is one of my favourite quotes from Mr. Justice Turner, which is in the Popper, Harker and Bagom case, which I'll refer to later on anyway. It was a case of actually not subletting of the whole, because the tenants in fact left the room locked. And so it couldn't be subletting of the whole, but it was certainly a breach of tenancy as well as other antisocial activities. And they were living elsewhere with relatives. And it was just a useful reminder, of course, that we're largely talking about issues of fraud, and particularly issues of fraud in the context of housing stock, which is limited and not available to meet all people's housing needs. And therefore, it's often a useful quote to start a lot of cases off in skeleton arguments. Moving on to the next slide, and of course, the crucial question of what subletting is. Well, of course, subletting is a parting with possession of the property, or indeed, in some cases, with part of the property. And certainly, if we talk about it in the context of subletting all the property, we're equally, therefore, talking about the fact that the tenant or the tenants, if they're joint tenants, are living elsewhere as their only or principal home. As you notice there, I spelt principal right, so that's always a good point. Only or principal home is clearly an important concept. I mean, if I go and stay with my dad, clearly my home here in London is still my only or principal home. If I hope the wife's not listening, if I stayed with a partner elsewhere, for a few nights, again, my home in London will still be my only or principal home. But clearly there is a point at which people's departure from their demised premises no longer is their only or principal home. And clearly that's relevant, because if you've sublet your whole flat or your whole house, then clearly you're not living there, and clearly it can't be your principal home. And that's, of course, the case even if you have an intention to return. And we'll see that that's particularly important when we look at questions of, for example, Airbnb, where you may not be letting it out for very long, but you have actually departed the property to allow somebody else to stay there as their only or principal home. If there is a subletting, and whether you're a local authority or whether you're an assured tenant for a housing association, of course, we're talking about social housing here, that would mean that the tenancy is no longer secure or assured unless it's a shared ownership, where it can go in and out of security of tenure. But if it's not shared ownership, it will mean that the security of tenure is ended for good, and it can't be returned unless you grant a fresh tenancy. But of course, you still need to end that tenancy, and the way you do that is with periodic tenancies by notice to quit. And I shouldn't have started this conversation, because with fixed term tenancies, it's a lot more difficult, because of course, and I will come on to that, particularly with the recent Supreme Court judgment. Unlawful profit orders are clearly available in those cases, and the purpose of unlawful profit orders is to make sure that the profit that tenants make from allowing others to stay in their homes unlawfully and pay them money is not retained by the tenant, and therefore unlawful profit orders are effectively the profit that are made by the tenant from the subletting. And looking at some case examples, the next slide. And before looking at these cases very briefly, because it's really the points that they make that I'm interested in, I just want to address some of the questions that have been raised already, as I say, when people booked on. There was a question about serving a notice to quit along with or without prejudice notice seeking possession. In other words, you may not know whether there's subletting of the whole, it could be subletting of the part, and if it's subletting of the part, most of your tenancy agreements will have a tenancy term which says that you can't do that without the permission of the landlord, and therefore there'll be a breach of tenancy, and the notice seeking possession will be seeking possession on ground 1 if you're a secure tenancy, or ground 12 if you're an assured tenancy. And the person commented that they get a good response that way. Flexible tenancies is a much more complicated thing. Flexible tenancies are secure tenancies which are fixed term. If you don't live there as your only your principal home, you end the tenancy by way of forfeiture proceedings. In other words, a section 146 notice. And what that means is that you have all the normal forfeiture issues arising. So in other words, the most obvious one is waiver. You know, if you've accepted rent from the tenant despite knowing that they don't live there as their only or principal home, have you waived the breach? Is it an irremediable breach? So there are issues there. Equally, and this is not really about this case, but it's really worth saying that if you've got, let's say, a ground 5 case, if you're a secure tenant, which is the obtaining the tenancy by false representation, in theory, you can only end it under that ground by issuing a section 146 notice, but one has to ask, what's the breach of tenancy? Because you're complaining about behaviour beforehand. All I would say at this point is that that's an article to be written and will be on my blog, hopefully in the next couple of weeks. And it's because of the fallout from Kalonga, of course, that we saw in the Supreme Court. There was a reference as well in the questions to mean profits. All I would say about mean profits, of course, is that if you end a periodic tenancy by notice to quit, you are entitled, the security of tenure ends at the expiry of the notice to quit, and you're entitled to use and occupation charges, which is normally, it can be higher, but it's normally the same level as the rent on a daily basis thereafter. It's fairly straightforward on that basis. And normally you should be telling the person that that's what you're doing. You're accepting it as use and occupation charges. The only other question we had under this section was about keeping family members on site or keeping a locked room. Well, Poplar, Harker and Bagom was the locked room case, and that just meant that it couldn't be subletting of the whole. But of course, if you've got a family member who is there, it rather depends. What's your arrangement with that family member? Are they paying rent to you? Have they got exclusive possession? Is it, for example, a caretaker arrangement because you've been incarcerated in prison for some reason and you're just wanting to make sure the property is available for when you're out? So there's all those kind of questions. But if the family member is paying you rent and have exclusive possession and you're living elsewhere, then of course it's subletting and you're entitled to possession, whether that's by notice to quit or by forfeiture. What these cases we then have show is that in terms of the kind of evidence you need, you can see from Brent and Croning, the first example, that shows that even if there's an intention to return in the future, so even if you don't intend to stay away from the property for years, but you're going to be working abroad maybe for a year and you decide, well, in that time I might as well get some money from the property, or you're having to look after an ill relative and you've decided, and this is one of the cases I had, I'm going to look after the property, I'm going to look after my mother, and therefore I'll let the property out while I'm not there, but I'm going to come back after I've hopefully my mother's got better. Well, those are still subletting cases, because even if there's an intention to return, you have sublet at a rent with exclusive possession the property, and that therefore you are still losing security of tenure. The Ujima case is interesting, really, because what it shows is that if you are remaining in the property as you own your principal home in any sense, then of course you can only have subletting of the part at best, and it may be you even have a lodger arrangement in those circumstances. It's a difficult one, and I've cited in that slide, you can see Crawley and Sawyer. Sorry, it's the previous slide actually, Raj, sorry about that. Crawley and Sawyer is a weird case where the guy stayed with his partner for many years. He actually got disconnected from his demise premises because he hadn't been there for so long. He actually returned to those premises after the expiry of the notice to quit, and the court still found it was his only or principal home. I don't think it would be decided the same today. But, you know, if you're not subletting the property, as Mr. Sawyer wasn't in the Crawley case, but you're just not living there, as long as you can get back before the expiry of the notice to quit, you're okay. Although it's a breach of tenancy, you may have court action because of that. And the next slide, the next couple of cases are just very briefly the Hussey case. The Hussey case is the one that confirms that it's at the expiry of the notice to quit with periodic tenancies that you have the ending of the security of tenure, and from that point you claim use and occupation charges. It's not the start of the notice to quit, it's when the notice to quit expires. And you can see the facts of that case set out on the slide there, so I won't just simply repeat that, but a useful case nonetheless. Lambeth and Vandra, which we'll mention later as well, the reason I've put that in there is that it was a case where there wasn't much direct evidence. And one of the questions I was asked is about legal thresholds for taking matters forward. Well, my experience is that you rarely have really brilliant evidence. You rarely have, for example, the subtenant prepared to give evidence in court. You often don't have, and we didn't in the Riverside case, have a tenancy agreement with the subtenants. In fact, in the Riverside case, from recollection, Raj, I don't even think we actually had any great records. We had some records of payments into the bank account, which we could clearly say.
Yeah, maybe a few, but not too many.
Yeah, because I've had cases where people have actually marked it going into their account, tenant's rent or something like that. So they're quite simple cases. But the Riverside case didn't have that. And yet it's one of those cases where you have to add up all the inconsistencies. You know, you go around there, there's somebody else there, not the tenant. There's locks on the door. There's somebody on the electoral register. There's somebody who says that they're a relative and they're not a relative, et cetera, et cetera. You add all that up and something's up, and the court is entitled to draw inferences. And therefore, the crucial message from this part of the presentation is, please, if you don't have direct evidence, it isn't necessarily fatal to the case. You have to look at all the other inconsistencies. I was asked about itemizing payments for the entire period of the claim. I think that's in relation to the unlawful profit order. Well, again, in the Riverside case, we had limited evidence as to, I was going to say we made it up, but that's obviously not right, Raj. But we had limited evidence as to the exact period of the subletting and as to the exact amount of rent that was being asked for from the tenant during each period that she was letting out the property. So we had to an extent guess a bit, and that was accepted by the court in Clerkenwell, so that was fine. I was also asked about the principle of estoppel applying against a landlord if they were aware of unlawful subletting but didn't do anything about it. Very good question if you've got a flexible tenancy, because of course you have to go down the forfeiture route. And it could be seen as a waiver, and you may have an argument about irredeemable breach, but there may be a waiver argument if you accept rent despite knowing that there's been unlawful subletting. But of course, with the periodic tenancy, the difficulty is that you can't regain security of tenure anyway, and your notice to quit, as a matter of fact, will have ended the security of tenure and indeed the remaining common law tenancy at the expiry of the notice, and therefore the concept of waiver, and I actually have got an appeal on this point coming up, but the concept of waiver doesn't apply in the same way to periodic tenancies. So it shouldn't be fatal to a claim, because it's not a question of reasonableness, for example. If you're doing it as a breach of tenancy, it would come into the concept of reasonableness if you were subletting the part and had known about it for years and had finally taken action. So subletting is a fairly straightforward concept, obviously very heavily factually evidence-based, and can lead, of course, to unlawful profit orders. And as I said at the start, if you look at the next slide, Raj, we actually have unlawful profit orders which are clearly set out in the Prevention of Social Housing Fraud Act of 2013. And in essence, what they're doing is saying, first of all, what is the period of your subletting? Once you determine that, what have you actually paid? What have you actually paid during that period? And then you say, okay, and what did you actually receive? And if you get a profit out of that, then that profit is the unlawful profit order, which is effectively a court judgment that can be obtained by the landlord or by the prosecutor in either criminal proceedings or indeed in civil proceedings. And normally, of course, in the civil proceedings, it's part of the possession claim that you have. There clearly were questions, and if we go on to the next slide, there clearly were questions, as we'll see, in Poplar Harker and Bagom as to housing benefit and how you treat that. But before we look at that, just bear in mind that, of course, you can get unlawful profit orders for subletting with part. And you can see that under Section 4 or indeed Section 5. But the key is that the tenant is not living there as their only or principal home. That's the key. It doesn't apply to shared ownership leases or PRS properties, but there has been some attempts, not successful so far, to achieve a similar civil remedy against shared ownership properties. But at the moment, it's not available in those cases. And looking at the next slide, which is the Bagom case. Now, the Bagom case, as I say, was a fairly interesting case, clearly reprehensible behaviour on the part of the tenants, both in terms of their activities with antisocial behaviour, but also in terms of their very kind of cute awareness. They didn't want to sublet the whole, so they kept one room locked. But even though it was subletting of the part, there was an unlawful profit order available because there'd been no permission given by Poplar Harker. And one of the questions that came up, and which the recorder, as with the other issues, got wrong, was the question of housing benefit. Because what they said was, well, look, we're only charging, I think it's about £400 a month. And therefore, you know, that's, and housing benefit was, you know, about the same amount. So we didn't make any profit out of it. And the court said, yes, but you don't pay housing benefit. It's not your money. And therefore you can't count housing benefit in that way. And therefore, you know, the actual profit element ignored housing benefit effectively. It doesn't matter which side of the equation you put it in, it effectively ignored it. The key is what did you pay as a tenant during that period out of your pocket? Not what did the local authority pay through housing benefit or universal credit housing costs if it's the government. That's the key question. And once you ignore that, there clearly was a profit element, and clearly Poplar were entitled to an unlawful profit order. Unlawful profit orders are very straightforward. They're purely mathematical equations. Once you've proved the subletting of whole or part, you are entitled to it. And in criminal proceedings, you are, in fact, it actually has priority over things such as fines, for example. So if you do have a criminal prosecution, as you can probably know from your experiences, you don't tend to get imprisoned for these kind of matters. You tend to have suspended sentences, and you tend to have then maybe a fine, but certainly you'd have an unlawful profit order which would take priority. Now, with the last two main slides, I just want to, before handing over to Raj, really, in a sense, that's the law bit, and that's, I suspect most of you understand that fairly well. But of course, there is this question about, yes, but have we got enough to go to court? You know, is there really enough there? Or is it just one of those something smells cases, and you think, yeah, we're not happy about it, but, you know, the subtenant doesn't want to help us. You know, they've now changed their story. You know, they've gone missing, whatever it is that you have problems with. And there are various things you can do about that. One of the first things you can do, of course, is, and it's not on the screen here, but is do a very good pre-action letter. I'm a big fan of a detailed pre-action letter setting out why you think something's wrong. It could be the visit by the officer, which talk to other people. It could be their references to rent. It could be, looking around and seeing that there was no evidence of the tenant being there. Clearly, that's easier in a one-bedroom flat than it is with a four-bedroom house. But there's clearly evidence. As with the Riverside case, there could be questions of locks on doors. And you don't necessarily need to know, incidentally, where the tenant actually lives. And in fact, we didn't know, I don't think. I mean, I think Raj and I had different views, but as to where she was living. But I have to say, I didn't know. All that we pushed the court to accept, which they did, was that she wasn't living at the property. Whether she was living with the separated husband or not was a moot point, but we didn't need to prove it. But even after you've issued proceedings, in fact, both before and after, you are entitled to ask what they call a request for further information. And you would normally do it after a defence is filed, because a lot of defences, either because the defendant hasn't said much to their own solicitors, or if it's themselves, of course, have chosen not to say very much, don't really say anything. So, you talk in your particulars of claim, for example, about the fact that, the claimant visited the property on whatever date and they saw, X, Y, and Z there, and they explained that they were paying, £100 a week for the room in the property, blah, blah, blah. And all you get in the defence is denied. You think, well, what does that tell us? I mean, are you saying that these people weren't there? Are you saying that the officer's lying in saying that they were there? Are you saying that they didn't say that they paid rent? Are you saying that they don't pay rent? What is it you don't say? And a Part 18 request for information is something you're entitled to do. And as I say, it's in the CPR Part 18. It's not a special form, but there's a way of setting it out, as you'll see from that part, which allows you to ask questions in relation to that defence. So you could say, paragraph 2, you say denied. Can you explain, A, do you accept these people were in the property when the council visited on this date? Can you explain why they were that property if you accept they were there? Etc., etc. And then you can get the information out of them. If they refuse to answer that, or if they refuse to answer that in a very coherent way or helpful way, you are entitled to seek an unless order. And that unless they answer the questions properly, their defence will be struck out. You still have to prove your case, but their defence will be struck out. So that's an important bit of information. Now, Part 31 is disclosure. In various respects. So 31.12, for example, is specific disclosure. So as you know, you will have disclosure after the defence has been filed, but sometimes you think, but they must have more information than this. They must be, not giving us something, and you can ask them for specific disclosure. Now that could be, if you're a housing association, it could be bank statements. And we'll see in a minute, the regulations allow the local authority to get those in any event, but it could be that kind of information. But you are entitled to make an application and say, look, we want particular information. And so, for example, they should be able to explain, what their position is with their employers, and so on, and what address they use for that employer and so on. 31.16 is disclosure before proceedings start. I say that just for sake of reference in a way, because it's quite rare. You can't use it as a fishing expedition. And it's not really something that the courts necessarily encourage. You have to really show that not only is this a matter where the respondent is likely to be the defendant in the proceedings, and that this is something that they would, normally speaking, have to disclose as part of their standard disclosure, but it's needed to dispose fairly of the anticipated proceedings. So if it's something that's fairly fundamental and could really answer the case yes or no, that's the kind of situation where you might use 31.16. Of more interest is 31.17, which is a disclosure against a person who is not a party. Now, again, the courts don't encourage that as a general fishing expedition. They need to know that it's going to support your case or adversely affect the other party's case. And that, again, what they say in the rule is it's necessary in order to dispose fairly of the claim or to save costs. Now, just to give you one example that my colleague Ryan had recently in a fraud case, on an alleged fraud case, I should say, there was a question as to the identity of the tenant, whether he was who he said he was, or whether he had stolen the identity when he came into the UK. And there was a request for information from the Home Office in relation to entry and passport details. And all they wanted really was a court order requiring them to do that, and they were quite happy to provide it, and that's what they did. Because clearly that was very fundamental to the case, because the alleged false information that they had provided to the landlord, in other words, it was a Ground 17 claim, was their name. You know, their name wasn't what they said it was. They had used the name of somebody who was able to come into the country lawfully. So that can be used rarely, but it is there to deal with. But what I would say generally about obtaining evidence is that you would already have data. If you work for a landlord, you will already have information. That may be information, for example, from a gas safety inspection. Maybe the report back from that says, well, it wasn't Mr. So-and-so, it was Miss So-and-so, whatever. There may be kind of conflicting evidence, which may be explainable, but there is that information. There may be information, of course, from neighbours, and it's often neighbours that you get the first inkling that maybe something's not right. The flat should be occupied by an elderly gentleman such as me, but in fact, there's a young family there who maybe not doing anything wrong themselves, but they shouldn't be there because they're not the tenant. And that's the kind of thing where you may, again, have officers investigating and finding out. You will have the pre-action correspondence I've talked about and the responses to your detailed pre-action correspondence. You would have the court information that I've explained through the request for further information. And you will have potential information which local authorities can get in investigating fraud matters under the regulations you see there of 2014, which is largely speaking bank statements of the alleged fraudster and their family, or utility accounts details, say for telecommunications. So you may have that information. You may have carried out a caution interview, which the tenant doesn't have to attend, but they may have attended and they may have said things in that interview which have helped. I mean, I've seen some of these interviews where they've suddenly changed their story when they've been presented with evidence, and they have a quick chat with their solicitor and they come back saying, okay, fair enough. At that particular day, I wasn't there, but they come up with some other story. And there may be some covert surveillance. But what I would say is important is and it's the second and third bullet points really, is that when you're looking at data protection and the concern about data protection, and our data, of course, is protected quite properly, data protection doesn't stop you asking anyone for information. Anyone can provide information that you wish, as long as they come within the particular exceptions which allow them to provide you with that information. Now, that can be done because the individual consents to it. It can be done because the tenancy agreement allows for it and clearly allows for it, and that's treated as consent. It can be done because you have anticipated legal proceedings, and then Schedule 1 of the 2008 Act mentions this. It's necessary to prevent fraud from certain organisations. And it's necessary for the administration of justice. There's always, in a fraud case that we're talking about, there's always some reason which you can provide the information if you're writing to a third party. Now, they don't have to provide that information, of course. It just means that they have the ability to do so. And if they do so, then that's good. And if they don't, you consider your Part 31 options as to whether you require disclosure from a third party. But data protection shouldn't be seen as something that stops you doing it. And data sharing, in particular, and the Information Commissioner's Sharing Code of Practice will assist on this, is really about agreeing in advance with certain organisations about what information can be shared in what circumstances. And it may enable, if you're a housing association, for example, to know that the local authority will assist you in certain information if there are certain issues that you have raised with them. So that's what I would say generally about the question of evidence. You can always ask for evidence. Data protection doesn't prevent you getting it in the fraud field. If you don't get it from a third party, as I say, you can go to court to seek that from them. And the last substantive slide that I'm dealing with, Raj, is the question of rules and submissions. Now, can I just have a plug for, well, first of all, a plug for Gordon Exell's brilliant civil litigation brief blog. If you don't go on that, then you really ought to. It's a brilliant blog, very helpful, and really updates you on civil procedure. And one of the things I often use is the question of, well, why haven't you got this evidence? And why haven't you got that evidence? And there's cases like UK Insurance that you see on the screen in front of you. There's cases like, I'll say this slowly, Ahuja Investments Limited and Victory Game Limited from 2021. That's AHUJA Investments Limited and Victory Game Limited, which make the point that it's not a rule of law, but a court is entitled to take account of the fact that if there is somebody obvious you could have called if you're right about your case, but you haven't, you've got to accept that that may be taken against you. And that can work both ways, of course. It could be the landlord that suffers that. It could be the tenant. But if there is somebody where you can say, for example, in the Riverside case, these great friends and family members that she claimed these people were that we saw in the property, well, of course, in those cases, none of them came to court. In fact, not even the husband. Well, the husband came to court, but he wasn't there as a witness. And she was there on her own. Why was she there on her own? If it was all very innocent, I mean, she said that her daughter, her adult daughter, still lived with her. Well, where's her daughter? Oh, she's at work. Well, that's the kind of thing that a court can take into account. We're talking about your home here. And if it really is your home, then, of course, in those circumstances, you are entitled as a court, you don't have to, but you are entitled to a court to say, I'm going to take that against you. You really should have been able to prove this if you're right in your case, and you haven't. And that worked for both claimant and defendant. I've already mentioned about lack of direct evidence and inferences, and it really is the case that, as I say, it's rare in my experience to have direct evidence of the real quality that you can say they can't possibly argue against it. It's more about looking at inconsistencies. And that's certainly what happened in the Riverside case. I would also give an example of another case I remember doing about succession, and they said that they were entitled to succeed. It was the daughter-in-law. And the real question was whether the tenant who had gone back to his home country of Vietnam, had he gone back there for a holiday or to live? And they never told us about his death until 8 years afterwards. And we managed to make submissions at the end of the trial and pointed out, I think it was 13 inconsistencies in the evidence, and obviously made the submission that we all make some mistakes when we're looking back on things and trying to recount things, but 13, which in themselves may not have been fatal, but as a cumulative impact meant that on the balance of probabilities, the evidence being put forward by the local authority was to be preferred, and that was accepted by the court, and therefore there was no legitimate succession, and therefore we're entitled to possession of the property. So lack of direct evidence isn't fatal to a claim by any means. You have to weigh up why they haven't been able to explain the answers to your questions in sufficient detail. Why you haven't been able to get evidence which may be better. There may be a good reason for that, and therefore, you know, the subtenant doesn't want to assist because they're scared of the landlord. They've moved on. There's nothing personal, whatever. And lastly, what I would say is that, of course, remember that the trial is really your only chance. There's no point being clever after the event. I mean, Ibidun was a case where they tried to say, well, we have some evidence as to how long the Gumtree advert was up, but now it's not so. We've got some new evidence now, and blah blah blah. And the court said, no, you had the chance to get that at the time. You know, you can't have two trials. You've really got to effectively, you know, make sure you're right the first time round, and you can't have two bites at the cherry. So what I would really say in summary about all this is that whether you're a housing association or a local authority has certain rights under the 2014 regulations to get information on these fraud matters. Anyone has the right to write to third parties to seek information. And because of the nature of the kind of work we're talking about here, that person would have the right to provide it. And if they don't provide it, one can go through the courts using Part 31 to try and get that information if it's not handed up voluntarily. And sometimes people want you to do that, like the Home Office, just to make sure that it's the court rubber stamping it and that they can't be criticised for doing so. And that one has to weigh up at the end of the day whether on balance of probabilities, you are right about the subletting, you are right about the own your principal home question, you are right about the unlawful profit order questions as to how much money was received. But the unlawful profit order is a classic example of you don't have to have pounds and pence detail to get a good unlawful profit order. And I have left you with my last slide, which is really just a quote from Lord Burnett, the Lord Chief Justice, in the recent Good Law Project case. General rule is that the evidence of a witness is accepted unless given the opportunity to rebut the allegation made against them, or there is undisputed objective evidence inconsistent with that of the witness that cannot sensibly be explained away, so that the witness testimony is manifestly wrong. I've put that in because in the Riverside case, she had mainly complained through her solicitors as to how we'd got information. And she really hadn't bothered to explain who these people were, why they had been registered on her electoral register for so long, why there were locks on the doors. And those explanations only came up on the day of the trial. And it's those kind of cases which the court is going to say, well, you've had plenty of opportunity to rebut the allegations from pre-action through to witness statements, and you haven't bothered to do so, and that can be taken against you. So on that point, I'll probably overrun badly. I'm going to pass on to Raj to deal with the question of evidence gathering.
Thank you, Andy. So yes, we're going to be talking about evidence gathering now and the pathway of finding the sublet, and also the key connections within the business, who to talk to, and also what information to ask for, and on-site evidence as well, and using your time wisely on site. We'll also be looking at internal systems and making the most of what we have to bring a case together, and the importance of partnership working as well. So we're going to be talking about witness statements and basic principles. So choose your witnesses carefully, and also be mindful of any sort of previous ASB history. So do look within your internal systems of notes, or any previous housing officers that you can speak to that might know about the case already, or about the particular person that wants to be a witness. Also prepare your statements properly as well. So if you have in-house legal teams, ask for some advice, and also get somebody to check over your witness statements internally. Or if you do have external legal teams, please do ask them. And then ensuring witnesses know their role and their purpose. So this also goes down to, particulars of making sure that, from start to finish, they know what their role is and they know what their purpose is, but also going into details of making sure that they're comfortable of travelling to court, and also ask their means of travel as well, or if they would like a member of staff to travel with them as well. Remember hearsay notices as well. It's important. I mean, I do remember using hearsay notice within our work, but just bear that in mind when you're bringing all of your documents together as well. And also be mindful of remote trials as well. And I'm sure that a lot of us during lockdown were exposed to Zoom online trials as well. Having an eye for detail is essential, especially when you're bringing a case together. I think it's important to check all your documents, and also make sure the staff that are involved in your case are aware of their witness statements in the terms of making sure that they're fully aware of everything that's written down that they've talked about, and making sure that they're incredibly familiar with all of the details as well. So who is to give witness? So, I mean, with the evidence and who's to give evidence, is what do you want to prove? And the main areas here are, the property, it needs to be tenanted by the tenant and used as their main or principal home. And also, do we need to show the profit as well? We'll talk about this as well going through the slides. And who is the best person to give evidence as well? So you might have investigators internally, you might have housing officers, and also contractors as well are also handy for written statements as well. Just bear that in mind. If you have contractors going into a property that have seen certain things like padlocks or mattresses on the floor, or someone mentioning something that doesn't seem quite right that's related to your case, then do bring all of that information together within your bundle as well. We've been kind enough by John Monkman to give us some hints, tips and tricks as well. And this is fantastic fantastic information because it talks about take witness statements early and don't assume the case will settle. Also, memory lapses with time, so making sure that when you are visiting or you are gaining some information or evidence, that you're writing it down as quickly as possible on I use a pocket notebook or on your system, so do bear that in mind. Allow your witnesses to tell their story and take notes, so giving them the space as well to speak, not interrupting is a good one as well, just giving them the space and the time to talk. And then outline is clear to take the statements in chronological order. This is great because when it comes to your bundle, everything will be all lovely and clear for the judge to read, and making sure that it's all in date order as well. And amplify the necessary details in the terms of, I would say, if you've seen padlocks, you know, really highlight that. On what door, was it on every door? You know, and you know, just go into specifics of things. You know, I remember on our case, we were talking about even, you know, the pile of post, or, you know, just certain areas where there is key evidence within your bundle. Also test out for points as well by searching questions within your own work is good. I remember doing that with Andy before and after as well, and just looking at the lessons that have been learned. And looking at all the facts in the right order and making sure none of it's sort of back to front. So when it comes to time to bringing all of your evidence together for court, that it's easy to read, but also clear and formatted really well. Technical information is a part of the text to clarify and not as a footnote. And each state of evidence should be rounded off and completed before going on to the next. And using subheadings is often great as well. So a massive thank you to John on these points. It gives a great explanation on developing a case and putting everything together for the housing association or local authority that are taking a case to court. So now we move on to the pathway of subletting. So looking at our internal communications, I would state and also mention that talking to housing officers is essential. Going on to patch sites and visits, housing officers will have a really good understanding as well of knowing their customers, the block layouts, any access issues, have they ever taken them to court, and also who to talk to as well, you know, what information to ask in the terms of and who to go to. Talk to operatives is great as well, because that will give you a good sense of how, you know, how many jobs have been logged. You know, is there a gap or a period of time where there was absolutely nothing being reported in? And also talk to asset officers as well. Look at any operational works or any access issues that they've had. Moving on here is looking at information and requests from regen teams, which I find really fascinating because you can get so much information from regen teams. They're absolutely fantastic at Riverside, where they will do their tenancy audits in the terms of knocking doors and trying to gain as much information as possible. And this is a really good way of finding out who's in the properties, any abandonments, anyone that's not engaging can also be key indicators of subletting. But I would also say that attending the meetings as well is essential, because you can go through every single property that they've had access issues of, or if they've gone into a property where they've been key indicators of subletting as well. So not seeing the right tenant, or they have, you know, someone has mentioned that next door, well, haven't seen them, but I've seen somebody else, something doesn't seem quite right. Riverside were able to obtain possession proceedings on a UPO last year for a great case that we did, and it started off with myself going on site with housing officer in Lambeth, and the housing officer mentioned there was a possible abandonment. We went to the property, knocked on the door, and something didn't seem quite right, and there was sort of no one answering, so I gave it a really good knock on the door, and somebody opened the door, and it wasn't the tenant, and it came quite at the forefront of us thinking, right, something doesn't seem quite right here. They did actually have a repair in the property, so we were able to gain access and just say, well, while we're here, we'll have a look and we'll report it to the repairs team, which we did. But as soon as we entered the door, we noticed something that just didn't seem quite right. But before I go on to the case a bit further, I'm just going to stop there and go on to the next slide, and I'll give you the next instalment in a moment. Now, just looking at the case that we had worked on and looking at on-site information and evidence, using your time wisely is really important, but making sure that you're considering the person's circumstances is important as well, because you don't know how the person got there in the first place. And it's really important to just give that person the time, and they'll also build up that trust with you as well, because if it doesn't happen then, it might happen later. I've had instances before where I will say, look, I know that you don't want to talk to me now, but here's my work contact number and you can contact me. And by the time I'm in the car or jumping on the tube, they will be messaging and saying, actually, no, you are right, something isn't quite right. And just being mindful of that as well. So asking them the right questions in the right way. Also, if you do see something unusual, and definitely in the terms of padlocks, build up a post or key objects, like if you see multiple beds or multiple mattresses, and take photographs and make sure they're clear as well. And look at the property layout. I only say this because I have been asked in court before about a block, sort of a property layout of where was the bedrooms, where was the kitchen, and you know, why were there, why do you think the bedroom or the living room had been converted into a bedroom? And having that clear sort of knowledge on the property layout is also essential, I think. Taking down full names and descriptions of the person as well, and put that in your pocket notebook or on your notes, and having a look if they do have vehicles, have a look if the property is registered to the housing association property address or local authority address. It's also, I find quite fascinating, is having a look at outstanding repairs, because it's a really good way of accessing the property later on. And if there is anything outstanding, then, you know, why were there access issues? And talking to the operative and saying, well, I've noticed that you were in there recently. Did you notice anything? And also have a look at fob entry systems. My favourite part, just having a look at how many fobs are registered in the property, and also see if how many times they've been, I know that Riverside have them in colour codes as well. So if someone's asked for 5 fobs, then that could be a key indicator as well, and a bit of a question mark around that. Best practice for me is when you're on site is having a pocket notebook. I think that when you are taking down information, doing it as quickly as possible is essential, good practice. And also when you're you're waiting for someone, somewhere to sit down and type away, I think a pocket notebook is great. And it really does sort of give you that confidence to look back at a case as well if you've been on site, and gives you all the information that you do need. So the next part of the case I wanted to talk about was when we entered the property in Lambeth. So once we were on site and we were able to gain entry into the properties where something just didn't seem quite right. And the first thing we noticed was padlocks on the doors, and including the bedroom door. So that was quite obvious, and that was unusual. I mean, if you're having people to stay in your home, you don't generally have padlocks on all of the doors, and your living room is generally not connected. Your living room is not converted into a bedroom. And there was a build-up of post as well in the kitchen, and the property needed some works doing to it. So bearing in mind, we were contacting the repairs team and making sure that we reported the job, and someone would be coming to do the repairs. Now, while we were having a discussion in the hallway with this person that wasn't the tenant and about the repair, someone else came out of a room that wasn't the tenant. So we were quite aware that it looked like a sublet. And when we soon left, the housing officer and myself were in the communal hallway, and there was a big argument outside and in the property, probably talking about the fact that we had entered the property and they weren't too happy about it. But before we move to the final instalment of this, I just wanted to go through looking at internal systems. So bearing in mind, with this case, we had been in the property, come out, seen all of these things that, you know, linked to a sublet. It was time to look at our internal systems at Riverside. So having a look at our internal systems in the terms of gas inspections, having a look at gas certificates, next appointments, and who even signed the gas certificate, which Andy mentioned earlier. I think in this Lambeth case, the persons signed their first name, the sublettee. So that was a good sort of link as well within our evidence. Having a look at outstanding repairs as well. Again, having a look if there have been any access issues. Having a look at correspondence is a good one as well. Having a look at the letters that have been sent to and from the tenants. ID documents, Riverside use Trust ID, which is really useful when you're out on site to check, and you're able to use that as an app, which is fantastic. And you also check how the person was referred to the housing association or local authority as well. How did they come about to have a property within social housing? So that would be interesting, because if there is any ID documents related to a referral, then you can check the documents via an app such as Trust ID. And also ASB indicators as well. Have a look if they've had any ASB incidences that have been linked to the property. That can sometimes give notes as well on specifics, like, well, my neighbour, I haven't seen them in a while, or anything key that's related to your case that you can use. And also have a look at the rent account as well. So if they're on housing benefit, are there massive arrears on the account or massive credit on the account as well? So that can be a key indicator. Have a look again at access issues, and have a look at the diary notes on your system. And again, we're talking about extra fobs being used. So all of these things were looked at once I'd left the property in Lambeth. And I would say out of all of these, there were definitely gas inspections that had been, that had been completed, but there were access issues, some outstanding repairs, and I think there was probably credit on the account as well. And that was the next step for us, was getting the repairs done in the property, and we were able to use the evidence from the contractors as well that noticed all of the items that myself and the housing officer had seen. So moving on, I would say that partnership working worked really well with Riverside. So with all of the evidence that had been collected, we went, so at this stage we saw the padlocks on the doors, build up of post. We did our own NAFN checks, which came up with electoral roll information that was key within this case. And but we weren't able to obtain sort of bank statements at the time, and that's where the joint partnership working with Oxford Investigations really come in, and they were able to really assist with that, and that was quite key in the evidence. So there were all of these parts, and our first court hearing came up. And bear in mind that Riverside had made serious attempts to contact the tenant, so phone calls, email addresses, door knocking, letters, you name it. We were trying to contact the tenant, but there was nothing, absolutely nothing. And so our first court hearing came up, and obviously they attended the first court hearing, which is always quite interesting. If you can't contact them, then they attend. So and with that, it was adjourned to go to a 4-day trial. And after that, this is where the partnership working really came into fruition in the terms of gathering sort of bank statements. And we were able to get a linked address, which I visited and was able to do some door knocking there. And we also had joint court attendance right at the end. So our full day hearing, a trial day, was actually, we had somebody from Oxford Investigations looking at our bundle and checking everything should be where it should be, and obviously getting statements from them as well, where they've also been doing some joint partnership working with us on the case. It was a great case where we were able to obtain possession of the property, bearing in mind that they would have, because it was a part of a regen site, they would have been gaining a brand new property and you know, the moving costs that come with that. So we were able to make the property safe again, and it could go to someone that really needs a home. And we were able to get the UPO as well of 145k. So, and it was the largest unlawful profit order that Riverside had ever done. But for us as well, it's making sure that our stock is protected is also vital. The lessons learned, I think me and Andy talk about this even now, is that I think partnership working worked really well for us, and finding those links as well, and also being able to gain financial records, and also getting Andy on board as well, you know, really did make such a difference. And Vicky Smith, who's now at Devonshire's, really putting the bundle together, making sure everything was okay, and then moving over to Katrina after that at Capsticks as well. And that really works well. And I think if you have all of the right people together with you, you know, with that focus of trying to get that good outcome, it really worked well for Riverside, and we were able to really work on, you know, the fact that this was going on for such a long time has made us think about like a 360 approach for our service of, you know, promoting this good work, but also looking at, you know, what can we do to prevent people unlawfully subletting their property, and having a look at, you know, training internally for housing officers, new housing officers, having fraud champions, and also making sure that we have contractors that are attending site that are also aware. So all of that work is going to be happening this year as well, which is quite exciting. But it's something that we're sort of looking forward to as well. So that's sort of the lessons learned from us. But overall, the case was a great example of making sure that partnership working does work really well, and social housing properties are protected, they're not misused, and they go to people that really need a home. So I think it's over to you, Andy.
Yes. Unfortunately, Raj, they had to look at me, which is very, very unfortunate. So we'll be paying compensation. No, we won't. So sorry about that for everyone. But can I just make some comments from the questions that have been asked? Can I just first of all confirm and really endorse what Raj has said about teamwork? But I have found, and we've even seen today with Garen being very helpful in answering some questions, I mean, the expertise of some of these investigation officers is very impressive and important. And I know the Oxford Investigation Service assisted Riverside with this. I've had people like Karen Evans, who's been brilliant in cases, you know, so a good investigation officer, you know, in the right case can be really helpful. And not least, of course, because you often have problems when you, for example, you get a credit reference report explaining it, and sometimes you need somebody to explain it because it's not always that clear what it's actually saying. And I know that Karen, for example, in one example, was brilliant in front of the court and in cross-examination. So that's very helpful. We were asked a question of caretakers. You know, the idea of if you're going to be away, let's say in prison for some time, you know, do you need the landlord's permission? Well, the answer to that is normally yes. I mean, normally, in fact, your tenancy agreement should make provision for that. And of course, what the landlord will be concerned about is it really a caretaker arrangement? In other words, you know, are you in fact making money out of this? Are you charging the person an amount which is more than what the rent actually is? So, you know, clearly you're going to want to be concerned as to do that. But I mean, obviously in certain circumstances, it's a perfectly reasonable thing to do and a reasonable thing to agree to. I would also endorse, by the way, this issue about other information. And indeed, I've got a lot of information from people such as Garen, from things like the Tenancy Fraud Forum Yammer account. I mean, the Tenancy Fraud Forum is an excellent organisation anyway, and the Yammer account is often coming up with issues, particularly to do with investigation, which obviously is not really my thing, but which is really interesting and really helpful. So I'd very much recommend that, as well as the Civil Litigation Brief blog. there was a question there about length of time away from the property. For example, for medical reasons, is there some kind of, well, if you're away for 6 months, that's fine, but whatever. To be honest with you, that's not how you can really approach it. Clearly, if people are going to be away from their property long term, firstly, of course, most of your agreements will make provision for informing you of that. And if they don't, it's a breach of tenancy, although it's rarely a breach that's relied upon in possession proceedings on its own. And of course, it's then a question of, well, is that real? I mean, are you really abroad or away because of medical reasons? And thirdly, of course, what are you doing with the property in the meantime? Because if you are abroad, if you, for example, and this marries up with another question, if you have family members in there, what are those family members doing? Are they paying you rent? Are they not just covering the rent, as in a caretaker type arrangement, but they're actually giving you a bit of a profit as well? So those are all the questions. So I wouldn't actually say there's a finite point at which point you can no longer accept somebody being away, but you really need to look into why are they away, what are they doing with the property in the meantime, and any monies received. There was a question about paying rent, although you're not living there. I think the question was related to being in another property of a family member, owned by a family member. Well, the mere fact that you're paying the rent on your tenanted property doesn't get you out of it. Are you living there as you own your principal home? As I say, you really have to look into the question of the quality of where you're living. So, for example, if you've left all your personal belongings in the flat or in the house, that may well be a good indicator that it's still your principal home, even though you're actually spending most of your time elsewhere. There's no rule that says you have to spend 7 nights a week. I remember dealing one question about when he was spent most of his time with his girlfriend, but it's just he came back at weekends, and in fact he only came back at weekends because the girlfriend's son didn't like him. So there are those kind of situations, but it really is a question of the quality of what you're doing. And so, for example, if you're moving out with a partner, there may be a time when you can still say, well, I'm not subletting or anything, it's empty, but I'm paying the rent, and I'll just see how it goes. But there will come a point, and it's impossible to say it's this particular point. But clearly what normally happens, in a Crawley and Sawyer type situation, you get to the point where you're saying, well, you've had your utilities disconnected, you haven't been there for a year. It's just not happening, is it? I mean, that clearly can't be your principal home. And therefore you're entitled to serve your notice to quit in a periodic tenancy case. And lastly, and I know there are some other questions, but lastly, and indeed, Raj, I mean, you're probably more used to this. There's the pros and cons of social media, and the only thing I would say very quickly is that it's very useful. For example, and I've trawled through things like Gumtree and so on. I know it's not strictly speaking social media, but that kind of thing is quite interesting. But yes, if you do have access to somebody's, I don't know, Twitter account or whatever that people use these days, Snapchat or whatever, then yes, that might be quite helpful, just as it is with lots of other cases. I mean,
it can be a good tool to use. I know that some cases, if someone's out of the country and they are tagged in something as well, it's a good sort of way of just utilising that. But I mean, I don't know how somebody could say, well, that wasn't me, or I shouldn't have been tagged, or it's been hacked, but it can be used in the right way. Yeah.
There was a question, incidentally, can we investigate 5 years ago and left it and go back again for making false statement fraud? Well, actually, I remember doing a case in Bromley Court where, in fact, I think it was about 11 years, 12 years maybe even, and we still got the possession order, outright order, because they had lied. It's as simple as that. And we had several properties which we managed to get the properties back. But obviously, the longer you leave it, the more difficult it is, because the courts are naturally going to be more sympathetic. And remember that the false statement ground, whether it's a local authority under ground 5 or a housing association under ground 17, is a discretionary ground. And therefore, again, it may come into the fact, well, is it really reasonable after 11, 12 years? Clearly it was in our case, but in other cases it may not be. And although there may not be a direct defensive waiver, clearly, if the tenant says, well, look, you knew about it. I mean, you just decided, you've got a new director and you decided to go tough on these things. Well, that may be a good answer to say, well, yeah, if you've known about it and you've just sat on your hands and allowed the tenant to pay their rent and maybe do a few improvements around the house, then fair enough. You're entitled to take that view. I mean, but they are discretionary, so of course it is a factor. But there's no time limit. Is the use of social media regulated by the investigatory powers regulations? Well, I suppose, Mark, what I'm talking about is accessible ones. I'm not talking about breaking into people's accounts and stuff. If people have open accounts, I don't see why REPA would necessarily kind of come into play. I'll have to think about that one. I wouldn't like to give a firm answer about that one, but I've certainly done cases, not necessarily fraud cases, but I remember an ASB case where we certainly used a Facebook account where she admitted bullying the neighbour. But that's an interesting question. I'll look into that, and I'll try and get back to everyone on that question of regulation of social media. And I think there was just then on the Q&A board, let me just check, there was nothing. There's a question that if a tenant has taken a short trial tenancy with another social housing provider during a secure tenancy, is it possible to successfully argue that secure tenancy was their main home and a principal home? Oh, I see. Well, if you've got two homes, you can't obviously be in your principal home of both. Assuming you're not subletting either one, you're entitled to go in and out of security of tenure, of course. And that's if all you're doing is not living in your property as only your principal home, you can go in and out of security of tenure, just as you can do with a shared ownership. You can go in and out of security of tenure because Section 15A doesn't apply. But so yes, the argument is that I remember having one of these, and he did defences to both claims, both claiming that they were his only or principal home, at both local authority properties, actually, for two different local authorities. And so obviously, he was found out as being a bit of a liar and lost on both of them. So yeah, it's possible to argue anything really, but if you're caught out like that, you've got to choose, haven't you, really? And there will be a problem. And Garam has very helpfully said you may be questioned in relation to REPA on social media accounts, but only if you keep looking repeatedly at the accounts. Thank you very much, Garam, for that. I mean,
that is true.
Right.
Look for once.
So yeah, and as Garam makes a very good point, that I mean, actually, covert surveillance is much easier for housing associations. You may have data protection issues, and you may have convention right issues, but you don't have the requirement to get authorization. And obviously, Garam knows more about that than I do, but you don't have that requirement. So very good point. So thank you very much, Garam, on that one. I mean, certainly, as I say, it's always interesting looking through some of these, particularly with Airbnb cases, some of these spareroom.com accounts, and it's amazing how people had one recently where they tried to argue that it was only letting out part of it, and it's like, it's a one-bedroom flat. What part are you letting out? So you're basically sleeping in the living room where this person's sleeping in the bedroom. I mean, is that really realistic? And they just named it like that. I agree with you.
I mean, I think there's also an assumption that subletting only happens in the south. And I remember that Riverside, when they opened the service up nationally, I think the first case that we looked at was in Liverpool, and it was an Airbnb case, and we were able to get again a UPO on that. But it just shows you that it happens nationally. This is not just in one area. It just it's just undetected. We have to just sort of find it, I think.
And remember that it's all about there's different reasons why people do it. Sometimes people just make a stupid decision because they've got a job abroad or they've got a job somewhere else in the country, and they just, rather than just tell the landlord they're moving, they just make a stupid decision. And sometimes people are just clearly in it for the money and just think it's a great money making scheme, and they can move in with their parents or their partner or whatever and make a few bob. Whatever they're doing, of course, it's both unlawful, although I'm more interested in the civil side of things, because I think you don't get much extra by going through the criminal route. And it really is, I think, about looking at how many inconsistencies you've got in the case. Because if somebody asked me where I live, I would hope I'd be able to prove it. It should be quite clear. you know, if they ask me who the other people is, I should hope I'd be able to explain who they are. But, you know, people often can't, and you think, well, that just doesn't ring true. And then, as I say, remember, it's a balance of probabilities. And although, of course, you've got the burden of proof, it does seem to me that there are normally some glaring, you know, inconsistencies. And in the Riverside case, you know, you have to say to yourself, when she was asked, for example, why have you got locks on the door? She said, well, it's a funny story that, you know, when I moved in about 20 years ago, you know, I had problems with the neighbours and I was really scared about them. And I thought I better put locks on the doors. I think, okay, that's 20 years ago, but now 20 years later, you know, and then, oh, well, what about these people? That's your sister. Well, I say sister, I didn't mean sister. It's just a term we use. Well, okay, that's fair enough, but it's obviously a friend. Well, she used to be a friend. Okay, what about the other one? Yeah, we don't really talk anymore. And the third one? You know, it just became so kind of everything had an answer why she couldn't produce the person to give evidence, produce a document to give evidence. And after a while, of course, the judge just thought, no, this is just on balance. Of course, the inferences must be that you're not living there and these people are. You know, why else would somebody have been on the electoral register for 12 years? You know,
I mean, just bear in mind, yeah, I completely agree with you, Andy. I mean, bear in mind that we have been locked down and as well. And during that time, people should definitely be using their properties as their main principal home, because, you know, you need to just stay at home as well. So that's key here. Our cases of unlawful subletting increased during lockdown, mainly because neighbours were noticing that, you know, they were at home and they were noticing that people were, you know, that wasn't the neighbour or something wasn't quite right. And so our cases just went through the roof at that time.
And it's a good example where neighbours are often useful in terms of evidence they've given to the officer, but they often aren't prepared to come to court. Now, I generally don't like the idea of witness summoning them because you just don't know what they're going to say. And it's often better just to leave it as hearsay evidence, you know, exhibiting whatever they've said, or, you know, the officer report of the conversation with the neighbour to the officer's statement. I mean, that's, to my mind, it's hearsay evidence. It's therefore not as good as direct evidence, which has been tested under cross-examination. But, you know, it's part of a greater picture. And you know, I think the Riverside. I mean, were you the only witness, Raj? I can't remember. Were you the only witnesses in that case?
Yes. Do you remember we could only have about 7 people on the day in court, so it was just me. Yes,
but there was no other witness statement, was there? I don't think.
Oh, yeah, there was my witness statement. We had we also had the contractors. We had Oxford Investigations as well, but in mine was hearsay as well, evidence where I'd spoken to stakeholders, etc., and other people.
Yeah, and you know, that's why you often get credit reference reports, for example, exhibited to the officer's statement. Again, you know, it particularly where it clearly explains something like, you know, electoral roll information. Of course, that's very useful. So yeah, it's, you know, it's nice if you can get direct evidence, and it's nice if you can be pretty sure. But actually, I say a lot of these cases, it just doesn't add up. And, you know, we are entitled, it seems to me. People are entitled, for example, not to spend every night in their house. People are entitled, if they want to go, you know, to their home country, to spend a lot of time in their home country. They're perfectly entitled to do that. But in other cases, of course, you are entitled to say, well, okay, we understand that and therefore that's fine. But in other cases, it's like, well, we don't understand it because the neighbours haven't seen you. In fact, they've seen somebody else. And that's where you start getting kind of suspicious. And even if the neighbours are saying to you, look, I'm not going to call, I'm not going to say I said it, but between you and I, this is what I'm telling you. And that's enough. And, you know, as I say, in the county court, it may be more difficult in the Crown Court, but or the Magistrates Court, more likely, but that's enough. If they own other properties but haven't sublet, and those properties are after they took on the tenancy, can we take them to court for possession? Well, all I would say, I remember giving the talk to Hackney just before the COVID, and saying, you know, of course, if you're Richard Branson and you had a council house, and that's fine, you know, as long as you still live in that house as you own your principal home. And then they said to me, yeah, but we got a term in our tenancy. And I think Croydon may have this as well, and maybe some others, that if you have another property, even if it's after you become a tenant and it's available to you or could be available to you and it's the right size for your household, then you're expected to leave, and it's treated as a breach of tenancy if you don't. So the answer to that is that although in theory, if you live there as you own your principal home, that's fine. If you've got the type of tenancy which then effectively penalises you from having a second property which actually you could move into rather than letting out to somebody else and making some money as an investment property, it depends on the tenancy agreement. But if you haven't got that, you're perfectly entitled to be a billionaire and living your social housing. I see somebody, so Gavin said Camden and Oxford now have these clauses. I mean, it'd be interested to see if it got up to a precedent level, because one of my questions to Hackney, I remember, was, has that worked? and they said, yeah, but it's all at first instance. So I'd be interested to see if it is ever tested. But in a way, it's almost like a flexible tenancy, which I have to say, I hate flexible tenancies and fixed term tenancies, a complete waste of time. But it seems to me it's like a flexible tenancy, but effectively doing it during the tenancy, isn't it? And saying, well, look, you really ought to be moving out and giving it to somebody who does need this property. So yeah, it's an interesting area, but it's been properly advised on. So on the face of it, you're entitled to have that as a term of your tenancy agreement. So thank you very much, Karen. What ground would you use on those cases? I think you would use it as presumably it'd be a breach of tenancy. Well, it's a good point with assured tenancies, of course, because with assured tenancies, you can do the suitable alternative accommodation ground. Although, of course, you have that issue about, well, you're not offering the suitable alternative accommodation. But it's been put into the tenancy terms, and so it's treated as a breach of tenancy, and therefore, it would be a ground 1 for local authority and a ground 12 for a housing association. So yeah. Making sure I'm missing anything. What are we now? Are we almost at the Tesco meal deal time?
We're at 12:16.
12:16. Well, look, what will happen is that I believe the slides are sent out. I think somebody may have actually asked about that, but it will certainly also be on the Cornerstone Barristers YouTube account. It normally gets up there fairly quickly because Caroline is incredibly efficient. So it'll get up there reasonably quickly. So if you ever want to have a quick look back and see what people said, that will be there. And I would just like to thank enormously Raj for contributing and effectively organising this in such a brilliant way. It's obviously a joy to work with, but also incredibly impressive. And she's even foolishly agreed to let me go out and do some home visits with her. But she may have forgotten. She may have forgotten that one. But no, it's a joy, and I just think it shows when you look at collaborative working. And what I would say, in finishing from my own point of view before passing to Raj, is that one of the things about the pandemic is that me as a barrister, I can have conversations with witnesses and clients much easier by Zoom. And I almost invariably with possession trials, I'll have a chat with the witness by Zoom, and it's much better than just having that 10 minutes before the trial itself. And as Raj said when she did her presentation, I think that's really helpful to really make it clear that it's very much a teamwork, and really the hard work and graft has been done before it even gets to me. And it's really useful for me to speak to the witnesses. So over to you, Raj, to finish off.
No, just a huge thank you, really, Andrew, because I think that having the right people makes such a difference, and I do believe in this, the collaborative work that we've done all together, really. And even on the day, it was a long day, but it was absolutely fantastic. And it just shows you that if you can as many properties as you can recover, it makes such a difference. There's a massive shortage of housing out there, and I think it makes such a difference. And it also protects the properties that we do have for housing associations and local authorities, to protect them, to make sure that they go to people that really need a home. But thank you to everyone that's been involved in the case. And thank you. And if you haven't already, I would definitely give a shout out to the Cornerstone Social Housing Fraud Book, because I think if you do have this service, then you need to have the book. I would definitely recommend it.
Okay, so thank you, everyone. And hopefully I'll see some of you in the not too distant future. Any questions, I'm sure you've got our details. I'm sure you can ask, and I'm sure we'd be happy in due course to answer. So I think that's it, and I don't know if I've got the ability to leave. But I think, as I say, thank you very much. And I think our next webinar is probably in a couple of weeks on the Kalonga case. So thank you very much.